What's up, everybody? Welcome back into another episode of The Lawyer You Know. Day 16 was a big one. The medical examiner took the stand. We weren't sure if she was even going to testify. There had been reports that the Commonwealth wasn't even going to call her. And people thought, will the defense call her? Will she become a defense witness? It was a pretty interesting back and forth as we got through direct examination, cross, redirect, recross. And then, of course, we had arguments at the end of the day that could be a major problem in this case that we will talk about. We will answer your questions. Make sure you guys hit the like button. Let's get to it. So much happened today. I didn't even mention the first witness who was back on the stand. Alessi continues with the cross-examination of the scientist. Last name is Hartnett, I think. And I'm just going to play a little bit of this. We're going to kind of work through her pretty quickly so that we can get to the medical examiner, which was the bulk of the day today. And so many things I think maybe we saw differently, right? As a lawyer, as a layperson, as somebody who could be on a jury, as somebody who questions witnesses and knows what it feels like when you get into some of these battles. I'll tell you what my thought process was on it. And you know, how I would feel if I was in that situation like Alessi was, and how you work through it. And also, I want to get what you guys thought. Maybe you have a different thought and a different view on it. And I love to learn from that because you guys represent more what the jury might be thinking. So let's start out with Ms. Hartnett. No salt, sand, or debris inside that taillight. And guess what, chat? That's all you guys could talk about yesterday. Not all, but that's one of the main things you wanted to know. And he asked it. And I really think that if you look at what Alessi did and what Hank Brennan did, because some of the questions Hank Brennan asked on redirect, I felt like came from the chat. And I'm sure you guys are watching all sorts of different channels in the entire true crime space, whether it's a different person that's a lawyer, a different person that's a true crime person watching this. You guys have these questions, and I think the lawyers are watching and listening as they should. I've had the opportunity to speak to different groups of lawyers, and I'm doing more of it this summer, and I tell them, you better be watching the chat. If you have a high profile case and you're not watching the chat, you're not doing your job. Maybe not you specifically, but somebody at your firm should be watching the chat. And another thing that a lot of people were wondering is Hank Brennan, and there's been some intimation that there was glass found inside the sweatshirt and inside the shirt and inside the wounds of John O'Keefe's arm. Is that true? Let's listen to this part across.
Over my lab bench, I took a long metal spatula and scraped any debris that was on these items into a small glassine packet.
Is it correct that you do not know where the debris came from specifically, other than it came from one or both items of both of these two items?
Yes, that's correct.
So the debris could be from just the hoodie, it could be just from the t-shirt, or it could be a combination of the both?
Yes, the items were packaged together, so they were already commingled. So there was no way for me to determine which debris came from which item, and it would be misleading to label them as such, so I combined them.
She also talks about how important it is to pack evidence with gloves and masks, and you have to be careful. Sometimes you need to separate them, not always. But again, every time I hear somebody explain how to do this type of investigative work and evidence collection, it is not what they did in this case.
Exactly where my next point was going to go to. Thank you. And my next questions. So what, if anything, were these two items contained in when you got them?
They were contained in a brown paper bag, and they may have been contained in a larger box, but I don't remember off the top of my head.
So when you got them and you saw them for the first time, using your term, they were commingled together, correct?
Yes, that's correct.
And was there any debris in the bottom of the bag?
There may have been. When I examined something on my...
Pretty important question. And she's like, there may have been. So they're in a bag together, debris at the bottom. They were on the floor of the hospital at one point. Like, all this stuff is getting mixed up together. How reliable is it? And this might become one of the points where jurors that are with the Commonwealth are like, haha, debris. That makes sense. Debris, glass, plastic from the car hitting him. And jurors that are not or are more skeptical are like, do we really know how the glass got there? Of course, Alessi points out, who packaged this stuff? Michael Proctor.
My bench, I also shake out the bag to ensure that nothing is left behind and that everything is examined and accounted for.
Now, am I also correct that there is no description of the actual debris that you found. For example, you didn't specify whether it was little fibers, little hair, little pieces of this or that. Do I have that correct?
Correct. I did not do any examination. I just packaged it.
And therefore, you didn't note whether any of the debris was a plastic or a plasticine nature, correct?
Correct. That would not be part of my analysis.
And there was no marker.
So unless they have another witness, Hank Brennan can't say there was plastic taillight, there was glass, there was anything specific in the sleeve. Unless there's another witness, right, that's going to testify, they tested it, it's glass, it's from the taillight fragments or debris was in the sweatshirt or in the shirt. This witness did not give him that. So he cannot argue that, or it is facts, not in evidence. At this point, right, there's still a long way to go.
Put on any part of the debris that was recovered. Is that also correct?
I labeled the debris with an item number. I'm not sure what you mean by marker, if that's what you mean.
Parts of debris, in other words, there wasn't separate identification or markers for separate pieces of debris.
No, I did not separate out the debris.
There was no photograph taken of the debris?
Not by me, no.
Do you have knowledge of whether there was a photograph taken of the debris by anybody?
I do not.
So you have, as you sit here today, you have no knowledge that there's a photograph of the debris.
That's correct, I do not.
When you received the hoodie and the T-shirt that's depicted as 150 and 151, they came in together, commingled with some debris at the bottom in an evidence bag. Is that correct?
I'm not sure if there was debris at the bottom of the bag. What I can say is that there was debris on the items, and I did shake out the bag. I don't have a memory of anything coming out of the bag. I don't know.
Okay. So there could have been debris at the bottom of the bag when you shook it out. You just don't recall.
Yes, correct.
If we could, Your Honor.
So I think he made a pretty good point. He made all the points he wanted to make there on cross. Brennan's redirect started out with red Solo cups. You've never seen it before, but do you know the circumstances that these officers were in when they decided to use red Solo cups in this investigation? He was trying to say with a straight face to the jury, this wasn't that bad. This was the best they could have done with the situation they were presented with. These cops did a great job. A red Solo cup was a great job. Didn't come off like that. Came off as maybe a little condescending to try and tell the jury that this is what it is. I have heard reports from inside the courtroom. I don't know if they're true or not, that jurors were literally laughing or giving side eye every time they talk about the Solo cup. Like they know it's a joke. And my thought with that is good. Good. I hope that they don't take this seriously or think that this is actually how police work is supposed to be done. I don't know any cops. Like if there are any cops in the chat, let me know. Do you think that's great? Because I don't. So this was a good point I thought made by Brennan on redirect. You looked at the rest of the car because we were all saying, and this was something I think maybe he's listening to the chat or people talk about this, but we were talking about, hey, all these miles on the car, there could be scratches, dents just from driving it, right? I think I said something like, I don't even want to go look at my wife's car right now. Well, he said, did you look at the rest of the car in whole? Do you remember any other scratches or any other dents, but for the part of the part of the car in question? And she said, no. I thought that was actually a pretty good point by Brendan. Does water act as an adhesive? Which again, a lot of you guys were saying in the chat, right? The water could cause the hair to stick to the car. The objection was sustained, but again, not a bad line of questioning. He starts asking if someone like wiped blood on it or basically planted evidence, would you know? Objection was sustained. Then he kind of asks her again, and she says something like, there are just way too many variables. And I thought she did her best. I thought she was incorrect at certain parts, but it kind of was what it was. On recross, Alessi shows her the right sleeve of the gray hoodie and says, you didn't perform any analysis as to what the source of the holes were. And he said, no. I personally thought this was potentially one of the worst redirects by Brennan. It was so clunky. It was so difficult to get through. And he didn't really get any points across that I thought he wanted to with this witness on redirect. He was asking questions that were inadmissible. Just the one point about the damage to the car, that was really the only good point he made on the entire redirect. And then this witness is like, hey, I want to correct something I said yesterday. And the judge is like, who was asking the questions? She's like, Mr. Alessi. And she was like, the judge was going to say, okay. But Alessi's like, whoa, whoa, whoa. Sidebar. That's not how it works. A witness is not able to just get on the stand and say whatever they want. Hank Brennan needs to ask the right questions. And if he doesn't ask the right questions, the witness doesn't just get up there and get to say, I want to say X, Y, Z. It's not how it works. People got annoyed at that. That's fine. That's a lawyer's job. We have to ask the right questions to solicit the evidence or corrections or rehabilitation on redirect. And if you don't, that's your problem. And it seemed like Judge Canonia was going to let her until Alessi was like, let's talk about it at sidebar. And then she was not allowed to answer or give that answer. Let's hit a couple questions here. Megan, hey, if an autopsy wasn't ruled a homicide, how is it allowed to be charged as a homicide? So medical examiners do not make charging decisions. Prosecutors do. The medical examiner in their report is only part of what a prosecutor analyzes when making that decision. That legal decision is left to the prosecutor. Not even the cops. They can arrest people, but if the prosecutor doesn't want to prosecute it, cops can't force them to. Doesn't a later time of death help the defense? We're going to talk about this when we get to the argument at the end of the day, but regardless of if it helps the defense, changing stuff at this point is still problematic. Do you know Al and Bert Kreischer? Is that the comedian? I don't want to say yes without saying, but like the comedian that always has his shirt off. I'm picturing like a guy with a beard. I think I've seen him before. Why do you ask? Where do I go to buy your merch? LawyerYouKnow.com. No, just LawyerYouKnow.com. You've said in the past you wouldn't try this case, but do you think if you were a prosecutor trying to get justice for John O'Keefe, you would bring a case even if you aren't sure if you have something like beyond a reasonable doubt? No, I wouldn't. I would have the difficult conversation with the victim's family. That's also part of our jobs as prosecutors. Hey, Peter, when this witness wanted to correct the record at the end, if she asked it during the questioning, would she have been able to? Better for the defense or prosecution? So if she would have brought it up, theoretically, Hank Brennan could have said, was there anything you wanted to correct yesterday about your testimony? And theoretically, she could have answered it. There could have been an objection, too vague, open-ended, but I think the judge would have allowed her to do that. But because she brought it up after questioning was done, I think that's why she wasn't allowed to, because that's not proper. Thank you, Susan, for gifting 5 memberships. Okay, let's get to Dr. Scortibello, the medical examiner, whom a lot of people thought, and there were reports that she wasn't going to be called. And let this be a lesson. That is why I usually say, this is what's being reported. It's hard for me to believe, but this is what people are saying. There ain't no guarantees in a trial, right? Prosecutors, defense attorneys, they're able to adapt. All these people are on witness lists. Doesn't mean you have to call them, but it does mean you can. And Hank Brennan decides to call her. And let's talk about what he got out on direct. Experience, education, her role. Determine the cause and manner of death. If you can't conclude the manner of death, it is labeled undetermined. We get to John O'Keefe. There were law enforcement officers there or representatives there. She goes through the diagram of his injuries. We see about the right eyelid laceration, abrasion scrapes on the nose, right arm, superficial abrasion scrapes, bruising on the hand, explains superficial bruise, doesn't know how the superficial bruises occurred, doesn't really know how any of these injuries occurred. There was a bruising on the right knee, which I think is kind of helpful to the Commonwealth, just even before we get to redirect. If he was clipped, hit on the right side, right knee. Karen Reed in her own statement said, could I have hit his knee, hit his leg, run over his foot, things like that. Peter, what do you think Barry Scheck would have to say about the evidence collection? I can't think of a single person that would think this was done well. It's me, Melanie said, retired officer here. It is so bad. 4th and 5th rib fracture. But in this case, it was likely done because of the first aid. After the external exam, she does an internal exam, talks about the back of his head, removing his brain, what she saw. Toxicology for John O'Keefe, ethanol between 0.21 and 0.28. And then we get to, so that was basically most of her direct. And it feels like they got almost nothing from her direct examination, almost nothing good. Frankly, undetermined manner of death is bad for the Commonwealth. So why did they call her? The only thing that is potentially useful, we're going to watch it together here, a couple minutes of this direct examination by Hank Brennan.
Autopsy and observations of Mr. O'Keefe's body. Inevitably, did you come to a conclusion about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about the cause. To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes, the cause of death was determined to be blunt impact injuries of head and hypothermia.
You mentioned 2 different things, blunt impact and hypothermia. Was
Correct.
there a primary cause of death in your opinion?
The blunt impact injuries of head.
Hypothermia, was that sufficient to be a primary cause of death, in your opinion?
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
So as weak as that was, the good part of this direct examination is hypothermia was a cause of death, not the cause of death, not the primary cause of death. But in the absence, after thinking about it, maybe without the head trauma, we could have hypothermia. This is the point of calling her. The Commonwealth felt it was important enough, I would think, because of what they know is coming later with the defense expert witness on this issue. But we're going to play a little bit more, but this is it. This is the peak and the best part, the climax of this direct examination of this witness for the Commonwealth.
So if I understand, you are not saying to a reasonable degree of medical certainty that hypothermia was the cause of death.
Not the primary. It contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, degrees.
There's going to be all sorts of questions and people saying like, that's too low, that's too high. If he was outside longer, it would be lower, but he was inside and they were trying to warm him up before he got to the hospital. So his temperature raised. I'm going to save all that for the experts. Guess what? Unless somebody proves to me beyond a reasonable doubt how important that body temperature is, I don't take it as such. That's what you're supposed to do as a juror. It's like, I'm not going to assume that's high, low, whatever. Explain to me why at that time when the body temperature was taken, it shows that he was hypothermia was part of his diagnosis as a cause of death. Just saying it and saying 96.3 or 98.3, whatever it is, your normal body temperature. The only thing I can ever think of is 98.3 degrees inside your mouth. That commercial back in the day, I don't even remember if it was like a gum commercial or a Slim Jim commercial or something, but regardless, explain to me why that's important and what it means. That's what the Commonwealth has to do with their witnesses.
Fahrenheit,
And what is a normal body temperature?
98.6.
98.
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
No, she was not. She was not able to a reasonable degree of medical certainty come up with the manner of death. That's important. That's obviously going to be highlighted by the defense. Brian Ailman, this is a great point. After a tough conversation with the victims' families, as the prosecutor, you need to have an angry and loud conversation with the cops. 100%. And I would have no problem doing it. I probably wouldn't throw them under the bus to the family because I wouldn't want the family to, add extra stress to them. But I would explain why I didn't feel legally and ethically we can go forward on it. And they probably hate me for it. And I get it, but you have to do what's right in life. You have to make that decision early on. That people are going to not like you sometimes for doing what's right, what you believe to be right.
After you complete your findings, including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yes,
And what is that document?
it's the death certificate.
Did you do so in this case?
Yes,
When you file a death certificate, do you include your ultimate conclusions regarding cause and manner of death?
yes. There is a death certificate that is issued immediately after the autopsy. The death certificate is a document that is necessary for the family in order to make funeral arrangements and proceed with their plans. So a death certificate is always issued at the end of the autopsy. If the cause and manner of death are known at that point, they are stated on the death certificate. If they are not, or if we need to do additional studies, then both the cause and the manner are listed as pending. And that death certificate is sufficient for the family to make arrangements. Later, as we get more information, as we get more results from our studies back, we issue an amended death certificate. So
I thought this whole thing was interesting. Like the 90 days, they can amend the death certificate. And I was thinking like, oh, so she had more time, more opportunity, more information, and still undetermined. This is not good for the Commonwealth. I thought a lot of the discussion on direct was not good for them. And I was like, now I kind of understand why you weren't going to call her. You know, maybe you were looking like you didn't want to look like you were hiding from her, but more bad than good for the Commonwealth in direct examination. Now, that's why this felt like the upside down world a little bit, because wait till I get to the beginning of cross to talk about how I felt like the defense did, but really not helpful to the Commonwealth. And Mo, I think these are great questions. Also, the questions like, was there grass in the hair? Would there have been grass if he hit his head on the grass? Or if he was dragged in the grass, there could have been grass in his hair. And, you know, all those types of questions. Again, I'm waiting for them to tell me why it's important, not for me to just figure out on my own, because jurors need to be explained and shown by evidence what these sides are trying to prove. Chris Yao, yes, the wintergreen gum. Inside your mouth.
Amended death certificate will have a cause and a manner. The amended death certificate in this case stated that the cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
Yeah, approach, Your Honor.
Yes.
Okay. So that's basically the direct examination. Then we get into cross. And by the way, so John O'Rourke said, what did you take from her examination of the arm injuries not being deep enough to be considered lacerations, just scratches? I mean, to me, I feel like either side can use that, John. So it's like all this stuff is not pushing me over the line. Like, I need the experts to explain to me this, to a reasonable degree of medical probability, happened from being hit by a car, or no way, couldn't have happened from being hit by a car. Her testimony did not prove that to me, but it wasn't supposed to. Her testimony is foundational for each side. Each side is going to build on what they get from her. And that's the purpose of her. Now, the defense focused a lot on that foundation and trying to build it. Alessi started his cross by talking about what she does, medical and legal aspects of the case, cause of death, determining why a body stopped functioning, manner of death, the circumstances under which the death occurred. He went through the 5 different manners of death. You can consider scene investigation, police reports, talking to cops, your investigation, obviously your autopsy. You are the specialist. You wouldn't want a cardiologist to perform this autopsy, would you? No. But then he asked an even more important question, because we know Hank Brennan has a big shot neurosurgeon that's going to testify about this. What does she think about a neurosurgeon's role in this manner?
Personally, or are you asking me that? No, I don't think every physician has their specialty and their training, and forensic pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
Would you want a neurosurgeon to be conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
I don't believe they've had the appropriate training to perform an autopsy.
This is a Commonwealth witness. That's not good. Now, Hank Brennan is going to do his best to explain why this is pointed and specific, being with the brain, neurosurgeon being the one to talk about the brain injury, how it can happen. So I actually do think that he'll be able to make him seem like a qualified expert for that purpose. But yeah, not to perform an autopsy. And anytime you get a chance for the Commonwealth's expert to take a shot at another expert, that's pretty huge. That's pretty huge. Heather said, I'm at my daughter's softball game, just stopped by another mom walking by to ask if I was watching Lawyer You Know, Karen Reed recap. She was waiting for you to start. Shut up. That's hilarious. That's literally hilarious. Bailey, found you a few weeks ago and I've been binging your videos and I'm new to the FSU family. Congrats, go Noles, baby. My dad started coaching there in January. What did he start coaching? I'm gonna have to look this up, Bailey. Share Tally Rex, go Noles. Oh, I have so many. And John always fights with me about where we're gonna eat when I'm in town. I love the old staples. I love California chicken. I love Gordo's. I love Hobbit hoagies. My favorite wings up there. I mean, I got so many recommendations. We'll get into it. How's that hair going to stay on the car when the snow was sliding down all over it? I thought that was a great point in cross yesterday. Netwoman, why would the ME be told about the accident? Shouldn't she determine the cause of death independently? So medical examiners, depending on the jurisdiction, are allowed to consider other things, which is why it's even more incredible and mind-blowing that she still determined that it was undetermined, the manner of death. I really think that you're picking up on exactly why this is so important. Because she was able to get all this other information. He talks about the scientific method and alternative causes. He asked her if she knew Proctor. And did Proctor tell you his working theory? Yes, in February of 2022. And you may think that's after the autopsy. Yeah, but it's before she had the 90-day period to come up and she could amend everything, that all the reports that she did still came undetermined. Then she shows a picture that I'm going to show you guys of not one, but two people that were there for the autopsy. I believe this is Officer Keefe, who said he was there by himself. Now, they have masks on. I'm not sure who they are. This is a bald guy, and we know lots of bald cops in Canton. So is it Proctor? Is it somebody else? I don't know. She didn't know. It said they have a sign-in sheet with, I think, names and badge numbers on it. I assume if that's going to prove who it was, we will see that. And you'll notice, I don't try to guess a lot. I try not to play figure it out. That's the lawyer's job. That's the Commonwealth's job to prove to me who it is. And if it's going to be a reasonable doubt or a hole or an issue in the Commonwealth's case, defense, point it out to me, please. Because that's your job as a lawyer. That sure doesn't look like one person. That sure doesn't look like Officer Keefe is correct. But I think he did say something like he was the only member of his unit. So maybe this was not a person in his unit. I don't really know. Sure sounded to me like he was by himself. And this picture does not look like he was by himself. Can agree to disagree if you want to. Then Proctor reached out to her again in March to talk about this. And let's listen to this exchange. This was the good part of Cross, in my opinion, in the beginning. We'll get to some of the issues I felt like Alessi had in Cross, but this was all good to me.
There was a person from crime scene investigation and someone from state police, but I'm working on a 2+ year memory.
Fair. That's fair. That's fair. I'm not going to ask you more questions to probe the memory. We can take that down. And yeah, we are finished with that. If you could hand that to the, thank you. Now, we were speaking about former Trooper Proctor. Do you recall former Trooper Proctor sending you a copy of scene photographs and wanting to schedule a phone call with you so that he could explain the status of his investigation? Do you recall that?
Yes.
And that occurred approximately in March of 2022?
Yes, approximately.
Right. And the method of communication of that was that by email, to the best of your recollection?
I requested that our medical legal investigator, we have our own investigators at the office that are responsible for obtaining medical records and sometimes being the liaison between us and law enforcement to get reports. I requested that she contact whoever was in charge of the investigation and set up a meeting, a phone call. So since it had already been a few weeks since the autopsy, I wanted to make sure that if there was any additional information that could be provided to me, I could take it into account because I had 90 days to issue a report and a death certificate on this case.
Now, you've mentioned the 90 days on direct. You just mentioned it now. Is the 90 days a hard and fast rule, or is it just something you aspire to as a matter of good practices?
It's not a hard and fast rule. It's something that as an office, we try to achieve. Again, the reason being that there are family members, next of kin that are waiting for these reports and these death certificates for various reasons. So is it possible to go over the 90 days? Absolutely, if necessary. But we do try to finish our part in those 90 days.
So it's possible to go past the 90 days, but there would, given the considerations you just articulated, there'd have to be a pretty good reason why you'd want to do that, right?
Correct.
And in this situation, you concluded that you had sufficient information on the medical side and the legal side to come to the conclusions that you needed to come to. Is that fair?
Well, I had sufficient information on the medical side because I did the autopsy and I had those findings. I did not have sufficient information that pointed to one manner of death over another manner of death. And therefore, I stated that the manner of death was undetermined.
Exactly.
And that's huge because if somebody purposely hit somebody with their car and you feel like you can prove that medically and you're her, you put that down. And she didn't. And that to me is a pretty major issue. Amy said, in your opinion, most impactful witness so far. So maybe this is recency bias and there's been a lot of witnesses, but two stick out to me. One, Yuri Buchanan. I think he was a disaster. I think his credibility was destroyed. I think that was potentially one of the most impactful witnesses. And then, honestly, the end of this witness's cross-examination and recross are starting to get to the most important parts of this trial for me and why it would be nearly impossible for me to convict based on the evidence we've seen so far. So hang around for that. Shelby said the body diagram was not the same as the first trial. Emmy said parts have been whited out. The document we saw during the first trial had many handwritten notes on it also. How has the diagram changed? I didn't put them up side by side. If it was important and those edits are good for the defense, again, I'll sound like a broken record. I expect the defense to point that out to us.
And so the manner of death is undetermined. I want to, if I could, with you pursue that a little bit in a moment. But when you came for the end of that 90-day period, you had information from the law enforcement side on their theory of what had happened, correct?
Correct.
Michelle, we're going to talk about this a little bit when we get to her recross and he tries to do it here.
I'll let that one stand.
You had performed all of the medical investigation and analysis that you needed to perform. Is that correct?
Yes.
There wasn't something that you wanted to do on the medical side. You had mentioned, to be fair, you had Dr. Stonebridge involved as well. You had what you needed on that side, correct?
Yes.
And you therefore concluded on the manner of death that there was a not more compelling or more likely than other reasonable possibilities. Is that fair?
Yes.
So I thought that was great. And then he also talks about Dr. Stonebridge being triple board certified. Basically, she's the queen. And the defense wants the jury to know this. The Commonwealth objects, tries to block some of the pumping up language and bolstering language the defense wants to use in describing her. I found interesting. Did the jury pick up on that? Okay, Maureen, I must have missed this. So they said Keith and Connor. I must have completely missed that. So those are the two people on the log. And I saw another comment about how that was suspect. Alessi asked if she is familiar with Dr. Asik Wolf, and she says she's not familiar. And then, after a really great start to cross, I thought Alessi lost his way a little bit here. I thought it was difficult and clunky, and he got too bogged down on the hypothermia question. I already thought it was pretty weak testimony from her perspective that this was hypothermia. And if they have a really strong expert, I think he could have just blown her out of the water. But he really got into the weeds with these ulcers and these spots and the percentages of them being there and using all these big terms he had to spell and define that at times I was like, ooh. I think the jury might have been too. I think John O'Rourke commented on my Twitter post that he was like, this is boring. This is over my head. I don't even care. I don't even know what's going on. It sounds like blah, blah, blah. And I would be afraid as a lawyer that that's what's happening here. Daniel said defense dropped the ball on the internal injuries, focused too much on hypothermia, should have focused more on the cause of the internal bleeding, being kicked or hit with a bat. I mean, I think it almost sounded like there were more internal injuries this time than last time. And will a jury just kind of be like, ugh, throw all that out? Maybe the internal injuries were from being hit by a car. And jurors do stuff like that. I've heard them say stuff like that. And I'm like, what? Nobody even said that. But sometimes it happens. Gene, have we had testimony to the length of Karen Reed's taillight and the length of the injuries on John O'Keefe's right arm? Apologies. Work gets in the way of this trial sometimes. And only caught parts of the last trial. Gene, this is exactly what we're waiting for. This is what the accident reconstructionists have to do. Give us measurements, give us math, give us science. Prove this. We have a broken taillight. We have injuries in a pattern on his arm. Match it up, line it up, measure it up, and show us how this happened. We need that evidence. How can Bev deny a sidebar conference? A judge can. Doesn't that discount the defense in front of the jury? It can. The defense has the right to protect the record. They can keep pushing, but a judge can say, no, enough argument. I've heard enough. I've made my decision. They shouldn't really do it too much, but it is within their discretion, or to say, we'll take it up later. I don't love when a judge does that. I hate it. I absolutely hate it. You can overrule my objection, right? You can say you lose, Mr. Tragos. I disagree with you, but let me make my argument. Peter, thanks for your input. You might have said this already, but why is it that we watching it cannot see the pictures on the screen of John O'Keefe's face, legs, etc.? Hit the like button, folks. So there are parts we can see, parts we can't, and that's by order of the court. Could a juror request an answer to a question, even if it's been sustained? If I'd feel comfortable convicting without certain answers. So no, if it's not reliable, or the judge said it's not credible, or it's not coming in for some reason, just because a juror wants to know doesn't then make it allowable to come in. Doesn't mean a judge can allow it to come in. So if it's information you need and you can't get, not guilty. There's not enough there to prove it beyond a reasonable doubt. I was confused by all of the cross about the gastric ulcers, and that's right where we're going to get to. Are they trying to show he wasn't out on the lawn that long? Can't they also ask if gut punches or knees to the gut could cause bleeding? Yeah, but it doesn't seem like that's what it is, at least through this witness. It seems like he's trying to differentiate. What were they called? Not Kowalski. I don't know. I have it written down somewhere in here, and I'll get there. But there are certain kind of ulcers, and he says, well, you'd see those. You didn't mention those anywhere. And she goes, oh, I did see those. I just didn't call them that. And really what Alessi is trying to do is prove this was not hypothermia because he wasn't outside for that long. But it was so clunky, and he talks so much about internal injuries. I thought it got confusing. Maybe I'm just dumb or slow, right? I think that's a possibility. Maybe we have some slow jurors. The ulcer is so important, though, Peter. She did not write a report that was medically accurate. Okay, Miku's headphones. Do you think every juror picked that up based on these questions? You can be absolutely right. I am not going to argue with you. You could be absolutely correct. Do you think that it was clear? And if you did, good. The jurors got it. To me, it was incredibly clunky and confusing. Just this part. Wisniewski, thank you. That's just my opinion, okay? And I want to know what you guys felt as well. Okay, we are going to listen to a little bit of this back and forth.
And that's the primary cause, right?
Correct.
And then and I'm not clear on what you refer to on direct as a secondary cause of hypothermia, but you've used a little different phrase in some of your answers, and I want to make sure I got it right. Hypothermic considerations. Can you repeat what it was?
It said hypothermic changes.
Hypothermic changes. And you agree that you can have hypothermic changes without a conclusion of hypothermia, correct?
No, hypothermic changes are what I'm referring to are actual things that I can see in the organs that are consistent with hypothermia. They're anatomic findings. They're things I can see with my eyes.
So you can, I'm sorry, did you finish?
And those changes suggest and are consistent with someone being hypothermic.
And so we always use this in our trials as well, by the way, when the other side wants to act like, oh, there's no injury, their neck was perfectly fine, look at this MRI, it's fine. And we have the spine surgeon that actually goes in and sees it. And he's like, no, I saw how damaged it was and that it was traumatic, whether it's the inflammation or whatever, you can prove it's traumatic. And I saw it with my own eyes. And guess what? Your defense doctor didn't. So her being able to say she saw this with her own eyes and it was hypothermic changes, there was hypothermia there, that is powerful, I think. And there were a couple, Alessi usually has somebody locked in a corner. They're like an animal that's caged and he's doing what he wants to him, right? He's forcing him down a path. I don't think he did that as much with this witness on this one point. That's just my feeling on it. As a lawyer, he did not feel as in control of this witness as he has with just about every witness, especially the scientist that we talked about that was the last witness on the stand.
As you sit here now, with regard to, you use the phraseology consistent with hypothermia, signs of hypothermia, that's what I want to pursue just a little bit with regard to further information. We got started on this by asking whether you used the concept of differential diagnosis and hypotheses to determine the cause and manner of death. And you said in one of your answers that you relied upon law enforcement information, correct? Is that
Yes.
part of it? You brought that up. You're the one who said you relied upon that, correct?
Yes.
Which is just so good that she relied on law enforcement. So it makes it look like they're trying to force her to do something. The defense is definitely going to make that argument. And even after that, she still says undetermined. That's so good for the defense.
And you've brought that up on your direct testimony and earlier in the cross. Is that correct, that you relied upon the investigation of law enforcement? So now what I'd like to do is to ask you whether use.
So Kayla, I agree. He got much better near the end of cross and recross. So hold out for that. But this part, it was a pretty big chunk of it. I'm just giving you my honest opinion on it. What I saw, what I felt from him while he was asking these questions. Like sometimes these lawyers can really feel themselves. I wasn't getting that vibe in this section. And I get it. And it's hard. And sometimes you get wrapped up in it. And then once you're there, you still have to make your point. You can't abandon it. You can't show any signs of weakness. So I get it. And he's so smart that sometimes you can just tell he's so smart that sometimes I feel like it's hard to dumb it down for somebody like me, maybe. Yes, they did ask about the cuts of his arm coming from a dog. She said she's not sure. And it was objected and I think sustained. We'll talk about that in a little bit.
Using the concepts of differential diagnosis scientific method, did you consider whether Mr. O'Keefe could have died somewhere other than where the body was found and been moved and placed in the snow? Did you consider that?
Sustained.
May we approach, Your Honor?
Move along with this. We can approach in a bit.
Thank you. What, if any, alternative diagnoses did you apply to Mr. O'Keefe?
I don't understand your question.
What alternative scenarios did you look at, if any, for the cause or manner of death of Mr. O'Keefe?
I'll allow that question. What, if any?
At the time of the autopsy, I documented injuries and signs of hypothermia. I was provided with a set of circumstances. And at the end of the investigation, or at the end of my timeline, I concluded on the cause, but I did not conclude, or I did not determine a manner. The manner would be the circumstances you are speaking about, whether I considered other causes or circumstances. That's not how it works. I don't come up with hypothetical scenarios on how those injuries occur. I try to state the injuries, describe the injuries, state the cause of death and why that person died. And then I use all kinds of other investigative information that is provided to me to determine if I have enough to make a determination on the manner.
Did anyone provide to you any alternatives as to the finding of the body of Mr. O'Keefe in the snow?
Personally, to me, no.
And she
Did you ask?
So this is interesting. So Connor Keefe's. Oh, so I get what you guys are saying. Oh yeah, that is kind of strange. I don't know. Maybe there'll be more on it. So that was actually a part about them discussing like alternative theories, but we are going to get to that eventually when he talks about the ulcers. There's another part where he says, would falling backwards present this type of injury to his head? And I thought he had her. I thought she was going to give him the answer he wanted, but then she was like, yeah, I do expect that. And I thought he was a little surprised with that answer. And there were multiple times with this witness that I think both lawyers were a little surprised with the answer she gave. So let's listen to that exchange, because I thought he was right. Logically speaking, I'm like, I wouldn't think that's what the injury would look like if he fell back on hard ground. But she's like, yeah, I'm the expert. And yes, I would expect that. And I was like, oh, that's interesting.
Fair enough. Would a fall backwards on a flat frozen ground produce a circular and not a linear abrasion as depicted here on the back of an injured person's head?
Can you repeat the question?
Sure. Assume a fall backwards on a flat frozen ground. Would such a fall and impact present that type of pattern, or would it present a circular pattern, perhaps with something like a starfish in the middle?
I'll allow that. Can you answer that?
I can say that a fall backwards could very well produce that injury.
My question
I think he was a little, I'll just say, maybe he wasn't. I don't know. I'm not inside his head. I was surprised by her answer. SM, I agree. And I'm going to put a bunch of you guys are explaining what the ulcers mean. I agree. She didn't put in her report. First off, she should have called it ulcers. She didn't, but she said, oh, they're in there. I just called them something else. And it seems like it was semi-appropriate what she said. There weren't enough. Usually there's over 50% of it's hypothermia and there wasn't. And drinking can cause ulcers, and he's taking medication that will combat those ulcers and treat those ulcers. So eventually he brought it around. I just thought, what I'm saying is not that he didn't make a point. And I get a lot of us are hanging on every word these lawyers say, and we're like, that's the point that he was trying to make. I just think sometimes jurors can get lost in the weeds when lawyers find themselves wading in certain waters. And I usually don't feel that way with Alessi so far. Some other people do, the way he methodically goes through it. I did feel that a little bit this time. Shout out to my sister, Samantha. She's new here. I brought her as a reliable place to watch true crime. And also shout to Adrina, who has been accepted into law school, future lawyers. Where's the other one? Yeah, Brian said, I originally agreed that about the ulcers, but he was connecting the medication. Yes, and he's also for sure building a foundation for what they're going to ask their experts. I completely agree with that. And he ended up landing the plane. It was just a bumpy ride.
Is more specific, and that is a fall backwards where the person impacts the back of their head on flat, frozen ground. Would you expect that type of a laceration from that type of a fall? Not just a general fall backwards, but specifically a fall backwards where the back of the head hits flat, frozen ground. Would you expect that?
I could, yes.
And under what circumstances could a laceration like that and an abrasion, all of it together, what circumstances could cause that type from a fall backwards on flat, frozen ground?
Well, the laceration is due to the blunt impact, and so is the abrasion. The abrasion is friction. So depending on the type of surface, you mentioned flat, frozen ground, it's quite possible to have an injury as the one depicted. There's nothing inconsistent with this injury. And
that's all of this is great for the Commonwealth. This was potentially the greatest hypothermia in this point that Alessi ended up eliciting on cross was, I thought, the best part of her testimony for the Commonwealth. There wasn't a lot she did for the Commonwealth as a Commonwealth witness. She wasn't great for the Commonwealth. But this and the hypothermia were the best two parts. And unfortunately, Alessi's the one that elicited this testimony. Brennan didn't even ask it.
fall on someone's on the back of the head with a blunt surface.
Are you familiar with the phrase pattern recognition in medicine?
Yes.
And isn't pattern recognition something that requires training
I'm going to jump ahead a little bit to some of the discussion about, the Wisniewski's ulcers. When he said she didn't put in his report, I was like, oh, he got her. But then I was like, oh, did he get her, when she gives her explanation? So let's jump to that. And now we're getting to after lunch. So he starts to pick it up after this section, and it really starts to get much better.
Is it correct that if someone is believed to die, at least in part, from hypothermia, that in 90% of the cases of death from hypothermia, you would find Wisniewski's ulcers?
I do not know the exact number.
Is it that you're not recalling what the percentage is for the percent of cases for death of hypothermia that you would expect to find Wisniewski's ulcers?
I don't.
So do you recall?
Hold on. Move on. The objection sustained. So
Okay.
you're asking it. Yes. Go
Okay.
ahead.
EASMR, lawyers become experts in a lot of different areas when they try cases. They really, really do.
There were no Wisniewski's ulcers present in Mr. O'Keefe. Is that correct?
I believe there were.
Can you point anywhere in your autopsy report where the word Wisniewski appears?
I did not call them Wisniewski spots. I called them gastric hemorrhages.
Right. So you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages?
By the way, she does not seem flustered. She doesn't seem worried about anything. She's just like, this is what I saw. And this is what I do. This is how an expert should act. It's like, so I saw. You can disagree with me. I didn't call him that. I called him this. If you think that I'm an idiot for that, okay. That's how I do it. Which is even better for the defense that she was such a good witness for them. And why I wish this would have been just like a trimmed up portion, because he really got to it with the medication, with the drinking on the recross. And like LZ saying, yeah, I thought that was great. LOL, Mo. LOL. No, she did not. No, she did not. In fact, she went a step further. That got even better. Let me see if there was anything else I wanted to show here a little bit more.
In the pancreas are Wisniewski ulcers.
You mean the stomach?
I'm going to start with the pancreas.
Actually, I don't want to hear this again. It was like frustrating the first time, but you got the point of how I felt about that. All right. So then he starts cooking when we get to frostbite. And he indicated on John O'Keefe, 0 signs of frostbite. How important is that? I don't know. I assume an expert is going to explain that to me in the future. Would you like to amend that hypothermia was a cause of death? No, there were hypothermic signs. And he's like, hypothermic signs, but not hypothermia as the main cause of death. And then we'll get into the most important evidence from this witness. Why I said earlier when somebody asked, Amy said, who is the most impactful witness? The reason she is on the short list, Dr. Cordy Bello, is because of these 3 minutes we're going to listen to right now.
Examine him, which is at the time of autopsy, you had 0 signs of frostbite, correct?
Correct.
Dr. Cordy Bello, now that you have gone through your this part of your examination here today, would you like to amend in any way your opinions as to whether, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
In fact, there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Sustained.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident? Objection.
I'll allow that.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs and I did not see any evidence of an impact site.
And could you elaborate?
Not consistent with a motor vehicle accident. No evidence of an impact injury site on his lower extremities. Brandon's going to ask a question about a knee bruise, which we'll get to, but that feels like it could be a fatal blow for the Commonwealth, right? This is the medical examiner. This is why it's so important that she couldn't come up with the manner of death. That's humongous. And again, this is near the end of his cross, and this is where it really got good.
Elaborate to the jury what you mean by no evidence of an impact site?
I'm going to sustain that objection.
Why would you sustain that objection? It's like she's an expert. She just said something. Why can't she expand on it? I didn't understand these sustained objections here. I really did not understand it. Briny Daydream, I can only imagine.
What do you mean in your answer, no evidence of impact injuries?
I'll allow that.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs.
I would tend to agree. I'm not a doctor. I just play one on TV, but I would tend to agree. That's what I would look for too.
I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
Sarabi, I completely get it. I completely get it. I know it was going to be an unpopular opinion. And I think he's great. I think he's amazing. And I think one of the great things about really, really good lawyers is they can come back from it. And I think he did. I thought it was a really difficult trudge there for a second, but the ending of his cross I thought was really, really good. And he saved the best and most important points, which we're listening to now, to the end.
I'd like
All right, that was the end of that part, but there's one more clip. Oh, he says stuff like, if you fall back and hit your head, you're not going to get a cut on your nose or a cut on your eyelid, right? And then he even gets her to admit, while we've just heard her say, this is not consistent with a motor vehicle accident, but what could it be consistent with?
that category. Traumatic, did you use that phraseology?
Blunt
Blunt
impact.
impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Could be consistent.
There's your answer, Kiyoka. It could be consistent. That's not great. Yeah, Katie, I would agree with this. And we're going to talk about, recross, redirect, all that. I would agree with this, and I think he did lay the foundation. I don't know how many different ways I can say it. I just don't think it was very smooth. And I do think it could get lost in the delivery. I do. I think if I asked him about it, he would probably agree that that wasn't the best part of the cross he's had in this trial. But he landed the plane, and that's the important part. Let me see here if there was anything else. Oh, there were pattern injuries on his arm. Those injuries to his arm were pattern, but the judge didn't really let him get into the fact that, or was it a dog or not? And then when he gets to the manner of death, is it fair to say you had doubts, reasonable doubts? Objection sustained. That's actually not a proper question. You can't do that. You can't enter the province of the jury, have her answer the ultimate question. And it's fair. You wouldn't want him to be able to ask the cops that. You wouldn't want him to be able to ask all these other witnesses that he has, meaning the Commonwealth. So it's not an appropriate question by the defense. I don't think he was at all surprised that that objection was sustained. Okay, let me ask. There's so many questions that are about the end of the day or Brennan's redirect. So I want to try to ask him at the right time. But Brennan on redirect gets up, says, you've done 1,200 autopsies. It's fair to say you need to give your entire grand jury testimony, not just a part of it. He's leading, totally inappropriate, saying he's trying to trick you unless he's not giving you this in context. Isn't it important to read your question in context? I don't even think the witness was like, okay. And it was also so unimportant because she already explained the context that Brennan had her add, right? Where it was like, yeah, hypothermia, all sorts of other details and backgrounds, right? That you need to know, other parts of it. And she's like, yeah, I know. And she explained that already on cross when Alessi was asking her the questions. So really ineffective beginning to redirect. And then a completely inappropriate redirect where he was able to once again go through the entire evidence of the case and ask her if she knew all of it. The only problem was, I think he was very surprised by her answer that she knew almost every bit of this. And we're going to listen to the big chunk of redirect where he goes through all this stuff. And he's like, but did you know the defendant confessed and said, I hit him? And she's like, yeah. And even after all this, still undetermined? Let's take a listen to how it was presented to the jury. I don't even think he should have been able to do this. But sometimes you're given just enough rope, right?
Considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant,
I'm going to allow it.
that the defendant said,
The reason I think if I was going to try to help Judge Cannoni out as to why she made this decision, the defense did talk a lot about what did you consider? Law enforcement told you, you knew their theory, you knew X, Y, and Z. So the defense did try to make it seem like she knew everything. And I think Brennan thought he was going to come and be like, you didn't know everything. Look at all the stuff you didn't know. But it turns out she did know most of it.
I hit him. Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
I don't think he was expecting that. He's like, wait, you did know about that? But it was probably after your 90 days, right? No? Uh-oh. Like once he asked that one question, he should have been real careful. He just kept going because the judge let him. And he's like, oh, I've got it. Now I'm going to go bring this home. It's like, you're not bringing it home.
Were you aware that there was another first responder by the name of McLaughlin who provided information that the defendant said, I hit him, I hit him, I hit him, I hit him?
Yes.
Were you aware of statements made by the defendant, to Ms. McCabe, that she said, may have I hit him? Did I hit him?
Objection, may we approach, please?
Okay.
So she doesn't know about the McKay part. We're going to skip the sidebar here.
This is not goes to Dr. Scordi-Bello's knowledge.
At
You
the
said this is not for the truth of what he's saying. It just goes to, did she know it in her evaluation?
time of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Ms. McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
I was aware of that information later on.
It's like, what? You knew all this stuff? You knew all this stuff? But guess what? She knows what ARCA testified to. She doesn't know that ARCA testified to it, but she has the same knowledge in her head that this is not what it looks like when you get hit by a car. I'm not going to put my name on the bottom of this, no matter how much you guys want me to. Zoe B, that's rough. The stats sometimes make it look even worse than the box score looks worse than the game sometimes. It felt like this. It felt like this watching it live. All right, we're over an hour. Everybody hit that like button. We've got a lot to get to still. We got to still talk about all the arguments that happen at the end of the day. I've got a lot of questions to answer. So hit the like button. We're going to keep rolling here, even though we're an hour in.
Were you aware of the investigation regarding alcohol consumption?
Yes.
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
About their,
Their observations?
yes.
Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware that Mr. Whitley told the police that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given. Yeah.
She even knew that. She knew about the confession. I hit him. She knew about the argument. She knew about all the important details they're trying to tell this jury is enough to prove beyond a reasonable doubt. But guess what? Hers isn't beyond a reasonable doubt. It's to a reasonable degree of medical certainty. And she couldn't even get there.
Yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder. No.
That was one of the other very few things she didn't know. Penelope, that's interesting. Doesn't surprise me. Ugo Monk, Peter, is it risky to try and impeach the ME when she's such a good witness for the defense? Could the jury then discount the fact that she couldn't determine the manner of death? The fact that she couldn't determine it is not an impeachment. It's just great for the defense. Yes, people are asking, are there people helping them prepare? Yes, they have their own witnesses. That's absolutely a thing. I know somebody else asked that. Taylor, is it possible D purposely dragged out Cross with a Commonwealth expert to make it boring? So when their medical expert testifies, it's more engaging? No, I really don't think I don't think that that's happening. A lot of questions about Keefe. Can he be recalled? Yeah, the defense can recall him and say, who was that with you? We have a picture. I don't know why they didn't show him the picture. They had it. They could have impeached him with it. Taylor, they could have called just their own neurosurgeon that they had to talk about the cause of death and maybe the manner of death. I don't know what he's going to testify to. But they have other medical experts that they could call.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead?
Yeah, I was given that information.
And the questions of did I hit him? Were you aware of that?
He shows her a report that's got like 5 lines on it to try to make it seem like she didn't know anything. He did the exact opposite. He proved in evidence on the record she knew most of what the jury knows at this point. The vast majority of what the jury knows.
Yes.
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
Yes.
Were you aware of the statements that she made to the troopers?
Not in detail.
Were you aware that when they spoke to her on January 29th, she informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honor.
I'll allow that.
Yes, I was provided with that information.
Were you provided?
Even knew that. Unless he's like, objection. It's like, she even knew that. Touche. Yes, absolutely. Absolutely.
The information that she had never observed John enter the residence?
I believe that was part of the original information. Yes.
Were you aware that she informed relative to the broken right taillight she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it
I was not aware of that until much, much later.
after you filed your report?
Correct.
Were you aware of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature
So now that's his really big, that's his big key is the phone data. The phone data.
data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was not.
RS. So you think Brennan was trying to make her look bad because she was that bad for them? I don't think so, man. I don't think he would call her and then try to discredit her. I think he thought she was going to say she didn't know all this information. That's my guess. I don't know. Because he did it on redirect. This wasn't part of the planned direct examination. He thought, haha, I got you, Alessi. She doesn't know all the stuff the jury knows.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No.
Did anybody ever provide you any of this additional information you weren't aware of at the time, ask you to
Not after, but before they sure did.
evaluate it, and then reconsider your finding?
No.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs, either frontal or rear impacts?
Objection, Your Honor.
So now he's going to get into how different it is when you get hit by the front of the car versus the back of the car, which it is different. I'll just tell you right now, I've had a lot of accident reconstructionists, a lot of different doctors explaining causation of injuries. Never have I heard like, oh yeah, everything's different if it's a side swipe, or everything different if you get backed into a car. It's like, it's still a huge killing machine. It's not the same as a person punching you or pushing you or something like that. When you have a huge vehicle hitting you at 20 plus miles an hour, it's going to do damage. And if it just is scraping you or sideswiping you, it's probably not going to end your life. They're mutually exclusive here. Either it caught you and hit you hard or it didn't.
I'll allow that because I'll allow that.
Most pedestrian fatalities that we see are with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
How about cases where you had an opportunity to observe people who sustained injuries from being clipped, not hit, but just being clipped? Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
How about a sideswipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a sideswipe impact?
Could be.
She's like, I guess you're kind of reaching, but I guess it could be. But that's the best thing he got. That was the best thing he got on redirect, by the way, in my opinion. That bruise on the knee could have been from a side swipe. Okay, what about the scratches on the arm? You notice how he didn't even ask her about that? That's problematic when you're not even, you know, she's up there right now. And I've done this in closing argument before. Mo, a couple people said that. I did not notice it, but I listened to it a lot. Don't watch every second of it. So I had a witness, or I had a closing argument where the defense attorney, so I did my closing, the defense attorney got up and he shows this one like test. And he's like, look, this says it's normal. It's normal. And this is some kind of, neurological test that they didn't even want to ask you about. And it was like one piece of paper that had to do with like numbness in the face. It didn't have anything to do with what we were actually talking about. And so I got up on rebuttal and I said, members of the jury, do you remember the very nice double board certified neurosurgeon that the defense called? Did they ask them a single question about this neurological testing to act like it proved my client didn't have a neurological injury? Did they ask a single question? It was their own expert that they paid $1.3 million to over the last 3 years. I think he would have been happy to answer any questions they had about this test. No, they didn't ask him because it didn't matter. No doctor talked about this test because it's one piece of paper out of 3,000 pages of medical records. Go look at the medical records that matter. Go look at the surgical records. Go look at the life care plan and what they're going to need in the future. What everybody testified about, the important documents and testing that was done. They're trying to pull out these little pieces to try and trick you, but you know better. He didn't even think it was important enough to ask his own expert, right? And that's the same thing. Hank Brennan didn't ask his own expert. This medical examiner, we may know he didn't want to call her. The jury doesn't. This is his girl. This is his expert. Maybe that was offensive that I said girl. This is his expert. This is his medical examiner. She is there for him to help him prove his case. Why didn't you ask her about the injuries, the scratches to the arm, and whether that's consistent with a side swipe or a rear impact motor vehicle accident? I think we all know why you didn't ask.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that form.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Yes, she is. That it was not a motor vehicle accident. That's what it feels like to me.
Sustained.
You were asked questions about a nose laceration.
Yes,
And you offered that was not consistent with falling backwards on the head alone.
correct,
You were asked if that was consistent with a punch.
correct.
Objection, Your Honor.
That's not the testimony. That's your objection. Mr.
That
Witness.
is, Your Honor. There's not a question.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible,
Could it be consistent with sharp shards from broken plastic?
possible.
Could it be consistent with first aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
That's not what you want to hear. That's not what you want to hear. I always thought you're supposed to never ask a question you don't without knowing the answer. Sometimes you can with your own witness who you think's going to help you out. It's like we're on the same team. We represent the same smart tech, right? Like you're going to help me out, right? It's like, no, she's not. She's not. So you got to be careful. I feel like Brennan used this exchange as an opportunity to repeat to the jury a bunch of points why he thinks she's guilty. Absolutely, that's what he tried to do. The problem is this doctor expert knew all that stuff too and didn't think she's guilty. So it backfired a bit. Lita, Peter, can you please ask the chat to join attorney Mark Betterow on YouTube Defense Diaries, which will be on after your stream. I know you respect his commentary on this case. Thank you. That's cool. That's awesome. I'm Cora, not Chloe. Do you get time and a half for overtime? I should. Legally, I think I'm entitled to it. Were you aware that Proctor was the lead investigator? Were you aware that there was drinking in the police car? Yeah. Yeah, that was interesting. Do you think Alessi is going to do ARCA direct due to his arguments and motions? Wouldn't Jackson style be better to help highlighting the witnesses? I don't know. I think it's definitely going to be one of them too. I don't understand the relevance of the questions to the ME who did the autopsy. She was not investigating. It was based somewhat off of the defense's questions. Okay. Let's get to Alessi's recross here.
Yes.
And we're going to come back to that in just a moment. But do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying. Yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
This I thought was so much easier to follow, so much simpler. I wish this would have been the totality of what he got into about these ulcers on his first cross. But like I said, great lawyers adapt, they rebound, he came back, and boom. This is the last stuff the jury heard.
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Pretty simple, pretty straight to the point, and we get it, right? Mom of three, thanks for gifting some memberships. Sherry, Peter, how do you think John O'Keefe died? Your opinion as an attorney. My opinion as an attorney, there's no way to prove how he died beyond a reasonable doubt. The investigation was so bad. They dropped the ball so many times. I can't trust so much of what was done in the investigation that I don't think I'll ever know beyond a reasonable doubt what happened, which sucks. But Gene M, Peter, 1, thank you for what you do. 2, is it me, or why has there been no mention yet of the relation between the length of the taillight and the length of the injuries to John O'Keefe's arm? Is that not the implication by the Commonwealth? I don't know if I already read this or if somebody else said the same thing, but that's exactly what the accident reconstructionist should do. Mr. Agents, this judge is so one-sided and it's so obvious. How is this allowed? My girlfriend told me about your channel and I've been hooked. Yeah, I mean, there are times where it is brutal to watch. It's got to be so frustrating and annoying for the defense team. It happens in a lot of trials where the judge really favors the prosecution side and is heavily leaned in that direction. Did they double check all digital evidence like they did with Jen McCabe's phone search? Why not? It's a good point, right? Did they really dig into all this stuff and say, well, could this have been opened up at a different point, different tab? Were these text messages actually on the right time? Did they do all that? I don't know. Behind Rudy's fairing, did you catch the defense's arm injury slide said dog bite at the top? I did not. I did not. Zena, anyone else concerned that a jury of peers from Massachusetts might have lower expectations in the way LEOs should behave? Are Massachusetts residents okay with this? So I've talked a lot to people from Massachusetts just because of this trial. They've reached out and I've talked to so many of them. Thank you for reaching out to me. I've learned a lot from what you have to say. They almost automatically think they're corrupt. And I think that's part of the reason why, the defense was perfectly fine not moving this case out of this jurisdiction. Christopher, I wouldn't call it weird. I would call it the type of case that should not be here. That's the problem. If you feel this way about a case, we shouldn't be here. We're going to listen to a little bit more, about a minute more of this recross.
Attorney Brennan asked you questions moments ago, and actually several of them, of which included the words, did I hit him? Could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Scordi-Bello.
He's like, thank you in more ways than one. Thank you for your time. Thanks for answering my questions. And thank you for that specific answer. And that's how he sits down. So if you're the jury now, you've heard this expert who's very smart, who knows the medical side, knows causation of injuries, has seen a lot of car accidents, and she didn't have enough to determine that this was a homicide. How in the world are you, as a layperson, going to be able to do it? You know what? Not guilty. I can't do it if she couldn't do it. And Jackson brought it up in opening. I guarantee it's going to be brought up in closing. It's a tough one. It's a tough one to rebound from. Can the defense use court TV clips in closing? It's up to the judge. I think they should be allowed to. It's just like reading a transcript or reading a part or reading your notes of what a witness said. Aaron Blackman. And I think that's going to be a thing that's used more in the future. There's a gentleman sitting behind Mr. Alessi. I believe he's the appellate attorney for the Commonwealth. His demeanor changed with this witness today versus others. He didn't seem too happy at all. I wonder if that's a sign. I have no idea. Kathy, could her taillight have been broken if she did hit him? I would think even at 25 miles an hour, she'd need to hit something more fixed for it to break that much. I don't know. Not an expert, but guess what? We are going to find out and hear from the experts on this. Massachusetts gal here. Peter is correct on how we feel. All right. Azam said, where's the new intro clip? We got a copyright issue. We're trying to deal with it. It'll be here soon. All right. Now we are going to get to, as Welcome to the Episode Season 2 says, how do you think Aunt Bev will rule on the debacle at the end? Let's talk about this debacle. We're just going to play a little bit of it, but I'm going to mostly summarize what the arguments were that each side was arguing about, what the issues are, but let's listen to just a little bit of it.
Just gonna get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline.
By the way, this is outside the presence of the jury. They already left. They're arguing. Major problem. The Commonwealth expert has changed what he is saying. The time of the impact is on his expert opinion at May 8th, and we didn't get the report until May 10th. And what did he change? He changed the seconds from 12:31 and some change to 12:32 and some change. And while that might not feel or sound like a big deal, Judge, you know it is. We've prepped our entire case around this. I cross-examined Ian Whiffen, their expert on this, and how important this was to highlight the inconsistencies between the Commonwealth's own experts, and the jury can find reasonable doubts with the evidence, the lack of evidence, or the inconsistencies or contradictions in the evidence.
He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analysis. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a rule.
11th. That was 4 days ago. And ARCA already had to have all of their information done by May 7th. So you have to be able to respond, right? But this is not a response. This is completely changing your timeline after the defense has already paid their experts to respond and probably highlight that issue and that discrepancy. The defense has already prepared their trial for that. So this is not something that the Commonwealth is doing in response to the new stuff ARCA did May 7th. This is a complete change for somebody that already existed. I wish you would never remove that. I was going to say something else. I forgot what that was, though. I can't remember what that comment was, but we'll get back to it. MAGA Barbie. I'm sure Judge Bev will have grave concerns and tell the defense she expects a robust cross-examination of the Commonwealth's witness about his timeline change mid-trial. Well, I'll tell you how I think she should rule on this, and it's not that.
14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess.
He's like, was this calculated? Later he says, they have accused us of this, but this is the definition of an ambush. Ashley, it is completely outrageous. You cannot do this. You absolutely should not be able to do it. And I'll jump to the end here. Bev should absolutely not allow him to change this. What do I think she's going to do? I think she's going to let him. I think she's going to let him. I think she's going to let the defense let ARCA respond to it and change what they need to. She should absolutely let the defense, when crossing this expert, Mr. Burgess, say, up until May 7th, which is after, or May 11th, whenever it was, which is after I cross-examined Ian Whiffen, you changed the time, didn't you? You used to have it as this, but you changed it because of what Ian Whiffen said, didn't you? It used to be inconsistent, and now you're changing your test. They should be able to ask all of that. They should be able to go through the timeline, make it look shady to the jury. They should absolutely be able to do that. At the very least, Judge Cannoni should allow them to do that. Wait till I tell you what Hank Brennan wants to do, which blows my mind as well. LK, you're asking questions I don't know the answer to. Doesn't make sense to me.
Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffen's analysis. And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago in the data.
And then he goes into explain why there's no reason this has to be last minute. They've had some of this stuff for years, some of this stuff for months. They've been on board since October of 24, I believe.
From that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor,
I want to jump ahead to see if I can get what Hank Brennan asks for, which is just unbelievable. Unbelievable. John, yeah, I mean, we're going to see. We're going to see, that's for sure. Michelle, I don't know. I've heard people speculate about this. I'm probably just going to wait until we hear how the arguments come out and how the testimony comes out with the experts. I don't know. I don't know.
12:30, 1:38. And Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09. There is a variance between those times. We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box.
He should have already done all of it, Mr. Brennan. He should have already done all of it. Bethany said, do you think the Commonwealth regrets calling the ME? Why do you think they actually went through with it? I would if I was them. I would regret it. I think maybe they got baited into it. Maybe they didn't want to look like they were hiding from all this evidence or scared of it. Maybe they were scared of the defense calling her. I don't know. But I don't think it went well for them. It could have gone worse, but it definitely didn't go well for them. Okay, LA attorney for true crime. Yeah, I mean, it's always every decision has a risk and a reward, and that's how I think that went.
Relative to the time. Doesn't change anything. Doesn't change the data whatsoever. Just adds to the time.
It doesn't change anything. Changes everything. Seconds are important. But as somebody said earlier, I still think, even if Judge Cannoni allows him to do this time change, I still think there are arguments the defense has. And then maybe it'll even help the defense the later and later they push the time.
What he learned, from his opinion, is that Mr. DeSoto was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, it puts it in the same variance that we've been arguing from the beginning.
Like, we've been arguing this from the beginning. Well, if you already have that variance and you've already made those arguments, I would argue this, by the way, if I was the defense, because they're going to come back tomorrow and argue it even more, because Judge Cannoni's like, give me some other remedy defense other than not allowing him to change the time. And Alessi's like, I don't want to. That's what he should have to do. And Judge is like, you won't waive any of your arguments, but give me some other things. So he's got to go back and research, and they're going to come back and argue this tomorrow. But one of the arguments I would make if I was Alessi is, Judge, Mr. Brennan said they've been arguing this time problem or inconsistency the whole time, or variance, this time variance the whole time. So why not just continue down that road? That's what everybody's prepared for. If Hank Brennan says there's no difference, then keep the old time. There's no difference. Azam said I'm screaming at you again, so I apologize. I don't mean to scream. I don't know. I would say more Jackson than Alessi. Not exactly like either, but I would say more Jackson than Alessi probably.
The collision occurred at the same moment when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text stream data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over.
I was surprised to receive it. I might not have admitted that. Maybe he meant I didn't ask for it, or I didn't ask for him to make that change. So are the experts watching? Because I never heard Judge Cannoni say they could. That doesn't bother me. A lot of experts are allowed to watch trials, so that wouldn't really bother me. But is this expert watching? How did he know what Ian Whiffen said? How did he know that the time change and to deal with all that? Lisa, Peter, how can the defense complain in a legal way about Aunt Bev always rushing them along? It gives the appearance that she hates hearing them. Ask her to stop on the record over and over again, and maybe it'll become an issue for appeal. Speaking of appellate issues, Ginger said, if Bev allows us, would you move for a mistrial? It's not really a reason for a mistrial. You're asking for her to reconsider maybe, or it's going to be an appellate issue if anything else. If guilty, will this look on appeal? This would be a big deal to me on appeal, especially if she allows Hank Brennan to do what he wants to do. This also feels to me he doesn't really care about an appeal. He wants to win right now if I'm Hank Brennan. That's the feeling I'm getting from him. Appeals be darned at this point, because he's trying to ask to do for stuff that I don't feel like most state attorneys or prosecutors would ask to do. We know the taxpayers are funding for the Commonwealth, but who pays for Karen Reed's attorney's fees? They say they're pro bono, I think. Is the goal of the Commonwealth to bankrupt her to defend herself? I have felt that before in cases, so this wouldn't be the first time that was a strategy of the prosecutor.
On May 8th, which caused us to focus more closely. And
Wrong. I'm going to defendants do. So, and it's Mr. DeSogra, D-I-S. They got it.
What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that.
And Alessi said that, this should be a Rule 14 discovery violation. And Brennan, of course, brings up the fact that multiple times Cannoni has already found the defense to be in violation.
I want to phrase this properly. Efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case.
So now here's where he's going to ask for the unbelievable thing, because he's saying we're just given brand new stuff now from ARCA, and it's just impossible for us to deal with it because our experts are unavailable. Do you think the judge will give the Commonwealth more time for ARCA? Absolutely. I think she's going to give them all the time they need, but she better not. I shouldn't say she better not. It would really be a mistake if she gives Hank Brennan what he asks for here.
Well beyond the discovery deadlines without any excuse. And the court, understandably, has overruled government suggestion and has stated that it's going to allow the defense to proffer 2 expert witnesses in a very complicated field. And an issue that is at the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review and to prepare and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr.
He agrees. Most critical issue. That girl, AJ, seems like he really fears ARCA. Do you think he's playing dirty or he is a dirty lawyer from your experience? No, but I think he's trying to win. And I think that is the first and most important thing in his mind right now, which can be problematic. That's what it feels like. I don't think he's playing dirty, but I think he's dealing with what he has, and the expert changed his opinion, so he's got to deal with it.
Well, as you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case to the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information.
That's kind of exciting to me. ARCA has brand new areas that they're going to testify about, subject matter. Ellen, why hasn't the defense used the fact that Karen's car was in John's garage for at least 5 hours before she went to look for him? Could that be where the hair came from? They absolutely talk about how his DNA will be all over the car, including his hair potentially. But that doesn't work with the fact that they're saying there's no way that hair would stay on there. I think they're going with that it was planted. That's, I think, their primary argument.
Well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And
not to be disparaging, but our experts found issues, taking a shot at ARCA potentially. This is going to be spicy. This is going to be explosive. The accident reconstructionist battle of the experts is going to be the trial. It is going to be the most important part of this trial. Yes, Mara. So make sure everybody subscribes so we can get to 500K. Brennan said he was surprised to get the revised report. Is it common to not know what your experts are doing? Sometimes they do things on their own, and usually it doesn't go well when that happens. So sometimes that does happen. Potential big appellate issue, it could be. Depending on what Judge Cannoni does, it could be.
some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARCA witnesses. That's going to take time. We've heard from the ARCA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We will going to try to begin to prep at the end of the weekend. There's no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare.
Here's what he's asking for. That he's able to testify to what he's already had time to adequately prepare, which is in their case in chief. Now comes the wild part.
If either of these ARCA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing materials, actively engage in his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask.
Absolutely not. No way. So Z. McCarthy says, if Commonwealth splits the testimony, will Bev allow Sir rebuttal? Well, she should. She should, because the point is, Commonwealth, prove your case beyond a reasonable doubt. prove that that person is guilty of a crime, then we put on our defense and our experts respond to yours. Then rebuttal is limited if you want to respond, but you can't just call your expert for a whole other set of expertise and testimony on the new information, new testing, things like that. If you do, she should absolutely let ARCA come back and respond again. But that's just not how it's done. The Commonwealth is supposed to prove their case in their case in chief. That, to me, if Judge Canoni allows it, would be a major appellate issue. That is not how this is supposed to be done. Diana, Peter, have you ever seen a case with so many issues, so many open questions? Frankly, there's a lot of issues in a lot of cases, if I'm being honest. The wilder thing to me is like the text messages, the Google searches, the potential planted evidence, like the smoke that they have around all that stuff that makes you think there might be fire there. That's more crazy about this case. There's always a lot of legal issues, expert testimony, late discovery, witnesses saying things you didn't expect. That happens in a lot of cases. Laura, knowing stronger Karen Reed support in viewers, are you able to remain objective? I feel you are. Just curious. Viewership can sway objectiveness. Frankly, I don't really care if people disagree with me in the chat. Sometimes I like it more. What I don't like is people screaming, you're an idiot, or this guy's getting paid by the Commonwealth or paid by the, it's like, that's stupid. There's no reason to even discuss that. But I kind of like when the chat disagrees with me sometimes. Sometimes that helps me learn. This isn't my case. I'm doing this purely to learn and teach, I guess. So I don't really care if we disagree. And there have been cases we disagree with how we've seen things. Some people have left and been like, I'll never come back because I disagree, and that's fine. You've got to figure that out. You've got to understand that that's how it's going to be on this channel sometimes. So I say what I think. And just like today, I thought there were some bad parts for the defense. The Commonwealth is so woefully short in proving this case beyond a reasonable doubt that the end result didn't change. But I'm kind of breaking it down as a lawyer looking at it piece by piece. Rule 14 changed March 1st in Massachusetts to the prosecution. If the Commonwealth doesn't, do you think the defense will call Trooper Paul? I kind of hope for some comedy. I think they'll reference his report or his findings or opinions at the very least. How is Brendan ever going to get another client? He's a defense attorney, right? Yeah, me and my dad talked about this. We aren't as worried as you guys are. Some people are going to think this is great. This is the guy the Commonwealth hired. This is the guy they thought was such a good prosecutor. He's been inside that office. Let's hire him to defend us. I can see how you'd sell this. What's your biggest issue with Bev? The comments she makes in front of the jury, frankly. That's my biggest issue. And the comments she makes that are legally irrelevant in orders toward the defense. The popular bluff. My father's a new coach at FSU. Super chat is Herb Hand, offensive line coach. That's amazing. I got to meet this guy. He's got a new fan. Is he connected to Gus Malzahn and Mike Norvell, the head coach and the offensive coordinator? That's so cool. That's awesome. I got plenty of recs for him. Okay. Did you catch the end? If ARCA testifies, yeah, especially the new opinions, they're testifying. So Brendan's just asking for them to basically be able to testify twice, before and after ARCA in their entirety, not just in a rebuttal form, which is just so dumb and absolutely shouldn't happen. But there's going to be more argument on this tomorrow. So I'm definitely going to focus in on this tomorrow because I am very interested in this argument and how it goes. We're way over time, though. I got to go. I love you guys. I love hanging out with you. Had so much fun talking about this case with you today. So much happened. A pretty big day. Very important witness. But make sure you hit that like button, please, for me if you haven't already. Please make sure you subscribe. Tell other people following this case. Come hang out, subscribe, hang out with us. Tell me what they think, where they agree, where they don't agree. But that's all I got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.